years now. 2003.
Yes.
So that's about 10 years.
So before then, what was the laws regarding?
The laws were scattered. All right, the laws on various aspects of labor law. Okay, there were some law on the trade union, some law on
industrial
relations and things. But now they've put all together in
the Labor Act of 2003. Okay, what is the main purpose of the Act?
Yes, I think just like I was saying, the Labor Act really is to consolidate all laws on labor, formally. So now if a person wants to know the laws of Ghana relating to labor, you can just go to the Labor Act and you shall find almost everything there, as against what it used to be.
When it was scattered and you had to find from different avenues.
And then depend on other sources like common law and things.
What about the scope? The law
now,
type?
the Labor Act, when we started, we're talking about contract for employment and contract of employment. Now we are saying that if you're an independent contractor, that is, you are on your own and you are just offering service to somebody, you don't come under the definition of an employee,
right?
And therefore you don't come under the Labor Act at all. Now it's about contract of service, persons who are employees. But under the Labor Act, some services have been particularly excluded.
Okay.
These are the intelligence services,
the security
and
forces.
Intelligence services. We have the armed forces, we have the police service. Now we can add the fire service. We can talk about the prison service. We can talk about now SEPS have been added to.
That was a landmark case.
Yes, there was a case, and it was said that SEPS is also part of it. It's excluded from the Labor Act, and I think it's not there, but I suspect that immigration would also
fall under. There hasn't been any case yet. But
no. But
going by the SEPS.
Yes. If SEPS have been taken out, yes. In fact, the whole idea is that in certain circumstances, they are permitted to hold arms, firearms.
Right.
Okay.
So they can be considered as
intelligence service, and therefore they are out of it. Okay. And what this really means is that if such organizations, they cannot do certain things that other organizations can or services. For instance, they can form trade union. They are not part of the trade union.
Right.
All right. And then they can't go on strike and things. It's not permitted.
So the rules of the Labor Act do not apply to these people.
Yes. Okay. And sometimes they must understand.
So that is the main implication.
Yes. That's the main implication.
Okay. Now, let's go into contract itself. How is a contract of employment created?
Now, the law gives that it may be created by three ways. One, it can be written, or what's called express, and then we can have by implication. All right, these are the two main ones, by express or implication. That it can be written, it can be oral, or it can be by implication.
Okay. Let's take it one at a time.
Yes.
Let's start with the written contract.
Yes. The express.
The express.
Yes.
That's the written one.
Not necessarily written, but it's expressed. Whereby I agree.
So it can be oral as well.
It can be oral, but except that we agree that who is employing you? Do you employ me or employ you? Okay, let me say that I am employing you.
Employ me, please, by all means.
So I say that I am employing you. We can write it, or I can tell you orally, but the point is clear.
There must be an agreement.
Agreement that, and it is expressed. Okay. It's not the indirect one. That's the implication. All right. So when we talk about express conditions, contract of employment, we are talking about the part that the parties have actually agreed. Most often we expect that it should be in writing. In fact, the law states somewhere that certain things must be in writing. But the point is that it can be oral or it can be written.
Or implied. When it comes to express.
When it comes to express, implication is not part of it. Implied is different. Implied is where by conduct, all right, I've not told you expressly that I'm employing you, but by conduct, the way I treat you. Okay. I mean, I send you here, you go and come, and eventually I pay you money at a particular period.
You can get into lots of trouble with that one.
Yes,
let's take it one at a time.
All right, so we are talking about express. We are saying that it must be written or it can be oral.
Right.
Yes.
Okay. So can we go on there to what must be in the written contract?
Now, normally, Section 13 of the law, which I want to explain more later, tells us certain key points that must be in the contract of service when it's written. But it normally comes with a letter of appointment. Usually, when a person is employed expressly, so that it comes a letter of appointment, whereby you are delivered a letter that this is your employment terms. All right. And in the contract of employment, it will tell the rights and obligations of either the employees or of the workers. Okay. Yes, something like that. Yes.
Okay, so should we talk about the implied contracts then?
There's a lot more to talk about the express. Okay. Now, there's something that we talk about, conditions of service, and then collective bargaining agreement. It's not normally written and at the time of the contract of employment, but it is also it's normally embodied and it becomes part of the contract of employment. Let me explain well. Now, if a company or institution decides to employ you, you realize that they will give you a letter saying, okay, on this date you have been, and then you add that there are other terms in the conditions of service.
Right.
Now, conditions of service are normally some compilation of rules that the company or institution have put together. It's sometimes the booklet that you can refer to, and they say that it is part of it. All right, that's conditions of service.
Okay.
And even though it is given to you after the letter of employment, it is supposed to be part of the terms of the agreement of employment.
Please say that again.
All right. Now, what I'm trying to say is that, see, when you are engaged initially, we have the letter of employment, the appointment. Okay, it tells you, okay, I've appointed you to this post, and then maybe you end this. Then they say that other terms are in the conditions of service, which is that the company has created another booklet or another manual that has got the conditions. And those ones, if they want to write all in the letter of
are those some like general conditions, or they apply just to you?
Yeah,
exclusively?
general to all the workers in the institution.
Okay.
All right, but nevertheless, so long as you are there to, it can be used particularly
for you,
relating to you.
Right.
And then closely related to conditions of service is something called collective agreement. More precisely, it's collective bargaining agreement.
Okay.
Now, this is also after you have been employed. Now, the employer can meet with the worker and then to have an agreement on certain issues. That one, it is agreed upon. It is not like a booklet that they give to you at the time that you are employed. No, it's after employment, the employer may sit with you and then would ask questions. You will agree on certain things.
Right.
For instance, okay, my transportation to work, will you be taken by the office car, or will you? I mean, how?
So terms that are not included in the express.
Yes, in the letter of appointment. Yes,
okay.
They can be agreed upon.
Right.
But the important thing is that it is also added. Once it's agreed upon and signed, it is added to the terms of the contract.
Okay, Laura, we will be taking a few phone calls today.
Right.
So the numbers are up on the screen right now. If you have any questions relating to labor law or the Labor Act, you may call in, and Lawyer Samuel will be happy to help you. So, yes, let's go on then.
Yes.
So we're talking about conditions of service and the collective agreement. These are terms that may not be in the letter of appointment or be in the general terms of conditions, but you agree upon with your employer.
Well, the conditions of service, you don't really agree. It's given to you.
Right.
Okay. And let's say it well. Now, if after appointment, the appropriate thing that employer should do is that at the time he's engaging you, he should make a copy of the conditions of service. Normally, it's like a manual or a booklet.
Available.
He should make it available to you so that you read and decide whether you want to be part or not.
And if there's anything in there that you don't agree with, or something that should be there that should be there but it's not there,
yes,
you now agree. That's agree upon it.
Yes.
Which is now known as the collective agreement.
No, that's a secondary thing. But if there's something in that you don't like, it may change your mind as far as the employment is concerned. For instance, okay, you read it and you realize that, hey, at everybody's funeral, every staff funeral, you must go.
Or and you must contribute a certain amount.
And you think that personally is against your personal, ideology or whatever. So you don't want it. Based on that one alone, you can decide not to take the appointment. But what the problem that we have is that employers engage people. They'll just say that conditions of service, you not have seen it before. So you report to work and then later they give you the conditions of service. You read it and now you realize that
there are things you do not agree with. Okay, we've got our first caller, Baba Ali, all the way from Takoradi. Good morning.
Oh, good morning, my sister. How are you doing?
I'm very well, thank you. How are you?
You look so marvelous, so rococo, so gorgeous.
Thank you very much. Please go ahead with your question.
And the other gentleman, you look so wonderful.
Thank you.
My name is Babani from Takoradi.
Yes. Please go ahead. Oh, did we lose him?
Well, he just gave me compliments.
Oh, he just called to give us compliments.
Oh, no, he wanted to ask a question. I think the line dropped.
Terrible. Please try and call back.
Yes.
Okay.
Right. Yeah. So what I'm saying is that employers should do the right thing. The right thing is that as you are engaging a person, you write the letter of appointment. Then if you have any document called conditions of service, give it to the person. I think that a day or two, so that the person can read through and then decide that no, there are terms that I agree, there are terms I don't agree. Actually, there has been a court case on that one before. That one, I mean, a lady who thought that, well, she came to the company and realized that there are some things in the conditions of service that she didn't like.
Okay, so do you think that the conditions of service and the collective agreement should form part of the employment contract?
It becomes part of it. You know, for instance, the conditions of service, because it's stated in your letter of employment, as soon as appointment, when it's given to you, then it becomes part of it.
Okay.
But the collective agreement is discussed at a point, all right. Sometimes by the individual workers or by group of workers, they discuss it with the employers, and then they go. In fact, it's bargaining agreement. They go to and then eventually they sign it, and then when it is signed, then it also becomes part of the contract.
Okay, we have another caller on the line. Anthony calling from Bolga this morning. Oh, did we lose him? Oh, we've lost him. It's unfortunate. Okay, so I was going to ask you, can an employee refuse the terms of conditions of service?
Yes. That is why, before he becomes an employee, that is why it must be given to him before he becomes an employee. Because
okay, we've got another caller.
Right.
Let's go to him before we lose him.
Right.
Good morning, Jeffrey. Hello, good morning, Jim Fee.
Yeah, good morning.
Please go ahead with your question.
Good morning.
Good morning.
Yeah, I'm calling from Kamali.
Okay.
Yeah, I work with a company. They gave me a letter, but it is raw. There's no snake contribution, whatever on it. There's nothing. No.
Please say that again. They gave you a letter, and what's wrong with the letter?
Sorry?
What's wrong with the letter?
They give an appointment letter.
Okay.
But the letter, when I read it, it's just raw.
It's raw.
Raw.
Okay.
There's nothing for me in terms of something like an accident or something. But it's an insurance company actually.
Lawyer, did you get that?
Yes, I think that she expects more in the conditions of
the
letter of appointment than that he found. But that means that the company should have another document that will have the detail of what he's talking about.
Right.
For instance, he's mentioning that in case there's an accident, there's no provision for it.
Right.
You know, all these things, some of these things cannot be really embodied in the conditions of service.
Right.
In the letter of appointment. That's why companies prepare another document called conditions of service.
So when do you receive the condition of service? Shouldn't it come together with the letter of appointment?
Yes, I would even say that it should come, yes, with the letter of appointment. That if you go through interview process, you finally say that I'm employed this person.
Exactly, so that you know exactly what you're getting into. But there are situations where it doesn't.
Normally they don't. Normally you report to work. They've given a letter of appointment. You report to work, and then somewhere along the line, the HR will bring you a copy of the conditions of service.
Okay,
but some people don't know where it is.
We'll come back to that in a minute.
Yes.
So let's go to Irene from Takoradi. Good morning, Irene.
Good morning.
Please go ahead with your question.
Yeah, I'm enjoying your program, and I like your hairstyle.
Thank you very much.
Yeah, please, I have a problem, and I want you to advise me on.
Please go ahead.
Yes, I was employed in a certain company. Yes, they gave me an appointment of letter, like as a permanent worker. Later on, let's say at the end of the month, we were paid, like all of us were paid. And the second month of my work, my boss was like, I wasn't able to meet my target or something, so he's not going to pay me. Meanwhile, in the appointment letter, there was nothing like a commission worker or a target worker. So I want to know if it's the right thing that he did or he was pushing me or something. I just need an advice from you.
Okay, lawyer, over to you.
Yes, that is exactly the point. Next week we'll talk about some statements that should be in the letter of appointment or documents that will be given for appointment. And such things must be stated. The law will not permit an employer not having given a duty to or a condition rather to an employee to stay on another issue to punish the employee. It should have, if the employment is about commission, like she's saying, they should have been clear to the employee
at the time clearly stated
that yes, that this is the position. If you don't make this target, or if you make this target, you get so much. If you don't make this target, we deduct so much. And so then everybody knows. the law does not permit being taken by surprise.
Okay,
All right?
so with her current situation now, you're saying that it is wrong. The
Yeah,
employer
it is wrong.
cannot do that.
What the employer is doing is wrong.
So what actions can she take?
Well, like we go back to it again, internal first, because if you just rush, and then eventually there's a labor commission too that people can go. But you normally try to do a lot of, because employment is a relationship,
Exactly.
all right, and you want to keep it that way. So you don't just rush out and
So
just
she should exhaust the internal mechanisms.
But it is
before.
not appropriate. Then the boss should have said it so. Or maybe at this stage, maybe she can insist that now, boss, define it clear for me. What are you saying? That if I meet this target, I'll get so much. If I don't meet this target, you deduct. Then I understand whether I want to be part of this employment or not to be part of it. And then they can go up from there. But it must be clear.
Okay, all right. Irene, I hope your question has been answered. We have our final caller from Abu. Is it from Tamale? Kumasi, Abu from Kumasi. Hello, good morning.
Good morning, sister.
How are you doing this morning?
I'm doing great, and I appreciate the guy this morning.
Oh, I didn't get that, Abu.
I said I appreciate the program this morning.
Oh, thank you very much.
Thank
We
you
appreciate you for calling. Please go ahead with your question.
Okay. I just want to ask your man there that if a guarantor, you guarantee a work for someone and later on the person cannot define it work. Is it permissible for the company to arrest you or not?
Okay, did you get that?
Yeah,
Okay.
basically a guarantor to an employee,
yes.
and then there's something happens to the employee.
And then they can't find the guarantor.
All right.
Abu, was that the question?
Well, normally, when you guarantee for a person in law, it's likely to be because of money matters.
Right.
And you are making an undertaking that if the person, for instance, the person steals the company's money or something, you will refund it. That is the main idea about guaranteeing.
Not that you provide the person, but you will refund the money.
Yeah, that's
that is very
yes,
serious.
Yes, so you must be careful when you are guaranteeing. It's the assurance to the employer. You are now giving assurance to the employer that you take him on. If there's any problem, I will sort it out for you.
Okay.
So if, for instance, he has guaranteed for a person, and the person, for instance, has taken money, has stolen money from the employer, then he becomes liable. But the liability is not a criminal liability for the employer to call the police or something. It becomes a civil liability. So the employer can sue him, the guarantor, for the money. But it's not about arresting him, like he said. Yes.
Okay.
I think that's the dimension of the thing.
I think that's all the time we have today. But this is getting very interesting, so we will pick up again next week, Monday.
Yes.
Thank you.